Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax versus Hindustan Engineering and Industries Limited. This case has been reported in 453 ITR at page number 758. The matter has been decided by Calcutta High Court and the date of the judgment is 22nd November 2021. The facts of the case are very interesting. In this case, the assessee has sold one of its unit at Haldia, and in selling that unit, the assessee has sold some of its assets. And when these assets were sold, the assessee received the payment individually for those assets. But when the assessment was going on, it was the allegation of the learned assessing officer that whatever the assets have been sold by the assessee, whatever the unit has been sold by the assessee, it comes into the definition of sum sale, and the assessing officer invoked the provisions of section 50B, which talks about the sum sale. But it was the contention of the assessee that the facts and circumstances do not cover the slump sale because the unit which has been sold by the assessee has not been sold as a going concern unit. The assessee has not sold all the assets. Some of the assets were still with the assessee. The assessee has not transferred any of the liability regarding to that unit, and more importantly, the assessee has received the payment of the sale of the assets individually and not in a lump sum manner. In spite of these clear facts, the learned assessing officer invoked the provisions of section 50B, that is in regard to the slump sale. The assessee moved to the CIT appeal. The CIT appeal also upheld the order of the learned assessing officer. So the assessee was with the ITAT. The ITAT gave the relief to the assessee and said that in this case, this is not a case of a slump sale. The first reason was that the assessee has not sold the unit as a going concern. All the assets of the unit has not been sold by the assessee to the purchaser. None of the liability has been transferred by the assessee to the purchaser, which is a precondition for considering any sale as a slump sale. And more importantly, the assessee has not received the consideration for the sale of the asset as a lump sum, but the sale consideration was received as individual sale consideration for the asset sold. In spite of this clear decision, there was not much in this case because the facts were very clear. Even in that case also, the department moved to the High Court and the High Court also upheld the order of the ITAT that is not a fit case for slump sale. The department didn't stop here, and as usual, without going into the merit of the case, the department moved to the Supreme Court also. So the Supreme Court also upheld the order of the ITAT and High Court and said that in the present case, the conditions which are necessary to consider a sale as a slump sale does not meet here in the case of the assessee. So it is not in the four corners of the law to treat the assessee as a slump sale, and the Supreme Court also dismissed the special leave petition of the department. Friends, this is also a perfect example where the assessee has to face the litigation just because of the attitude of the department, that the department has to file the appeals in every case, whether there is any merit in the case, whether it is a straight case where the department has no chance of winning, in spite of the various circular of the Central Board of Direct Taxes that you have to file the appeals only in the genuine cases, not in all cases. But we all see that in our practical life that the appeals are filed without merits, and just to save their skin, the officers file the appeal against the order of the CIT appeal, ITAT or the High Court. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Hindustan Engineering and Industries Limited. This case has been reported in 453 ITR at page number 758. The matter has been decided by Calcutta High Court and the date of the judgment is 22nd November 2021. Thank you, friends.